A small business owner once made what he thought was a harmless hiring decision. He ran a background check on a candidate, saw a criminal record, and decided not to move forward. To him, it felt like he avoided an awkward conversation, but legally, he violated the FCRA. Because the moment you base an adverse hiring decision on information contained in a background check, you trigger a legal requirement to begin what is called the adverse action process. And if you skip it, you don't just create risk, you open the door to lawsuits, penalties, and serious compliance issues. Hey everyone, I'm Rodgers, the founder of iprospectcheck. We're a background screening company that helps employers run compliant background checks and build hiring processes that actually protect their business. And in this video, I'm going to walk you through how the adverse action process works and where companies can get it wrong. So let's start with this. Most employers think background checks are about finding problems, but the law cares just as much about what you do after you find something. If you take action based on a report, even partially, you have to follow a very specific legal process under the Fair Credit Reporting Act. And this is exactly where companies run into trouble. Not because they made the wrong decision, but because they handled it the wrong way. So let's walk through how the adverse action process actually works. First, before you make any final decision, you have to notify the candidate. And this applies to more than just hiring. If you decide not to hire someone, if you rescind an offer, deny a promotion, or demote someone, or terminate employment based on a background check, that is adverse action, and it triggers this entire process. So here's the first step. You send what's called a pre-adverse action notice. This is a written notice, digital or hard copy, that tells the candidate you're considering making a decision based on their background check. And you have to include a few very specific things. First, the full background report, not a summary, not a screenshot, the actual report that you relied on. Second, the official FCRA summary of rights, and it has to be the current approved version. If you use an outdated version, that alone can trigger legal exposure. And all of this exists for one reason: to give the candidate a fair chance to review the report, catch any errors, and dispute anything that might be inaccurate. Then, after that, you wait. The law says a reasonable amount of time, but in practice, most companies wait at least 5 business days. And during that time, you cannot finalize your decision. Then, finally, if you still decide not to move forward, you have to send a final adverse action notice. And this one has to be very clear and specific. You state your decision directly, that you're not moving forward with employment. You include a copy of the background screening report. You include the background screening company's name, address, and phone number. You clearly explain that they didn't make the hiring decision, that you did, and you notify the candidate that they still have the right to dispute the report and request another copy free within 60 days. Once again, include a copy of a summary of your rights, and at that point, the process is complete. Now, here's where most companies actually get into trouble. It's not that they don't know the adverse action process, it's that they don't execute it correctly. And the mistakes are usually small, but the consequences are not. The first big mistake is rushing the process. A company runs a background check, sees something concerning, and immediately decides not to move forward. They send the pre-adverse action notice and the final notice at the same time. Or worse, they make the final decision before the waiting period ends. That alone is a violation, because the whole point of the process is to give the candidate time to respond. Another common mistake is combining notices. Instead of sending 2 separate notices, an employer may try to roll everything into one letter. They basically say, we're considering this decision, and we've already made it. That completely defeats the purpose of the process, and courts do not look kindly on that. We also see companies rely on verbal communication. They call the candidate or tell them in person, but never send proper written documentation. That could create a serious problem, because if there's no paper trail, you can't prove that you followed the required steps. Then there's incomplete documentation. This one happens all the time. An employer sends the notice, but forgets to include the full background report, or they attach an outdated version of the summary of your rights under the FCRA. And even though that might seem minor, it's still a violation. In fact, many of these fall under what's called strict liability, which means regulators can penalize you even if the candidate wasn't harmed. But here's where it goes even deeper. A lot of employers think, if I follow the FCRA steps, I'm fully compliant. But you're not done yet, because the EEOC adds another layer. If you automatically reject someone because of a criminal record without looking at the details, that's a problem. If you can't clearly explain why that record matters for the specific job, that's a problem. And if you apply the same rule to every candidate, regardless of context, that's a problem. What the EEOC expects is something called an individualized assessment. You look at what happened, how long ago it happened, and whether what happened actually relates to the role that you're hiring for. Because without that, your decision can look discriminatory, even if it wasn't intended that way. So when you zoom out, most adverse action mistakes come down to this. Companies treat it like a formality, when in reality, it's one of the most legally sensitive parts of your entire hiring process. At iprospectcheck, we help employers manage and automate the entire adverse action process so they can stay compliant without adding complexity to their hiring workflow. If you want to reduce risk and simplify your background screening process, visit our website to learn more. And if you found this helpful, make sure to like, comment, and subscribe for more insights on background checks.